So the reason we're doing this class today is because Ricky does have he has expertise in an area that I think a lot of escrow officers do not. Divorce. Not that it's pretty and not that it's fun, but he does a lot of divorce cases. We have a couple agents in particular. They have connections to the courthouse downtown, and so they're appointed all the time on cases. I would say like one of them, 99.9% of the business is all divorce. In fact, it becomes even receiverships because it gets that bad with the whole case they do. So Ricky deals with this on a daily basis. I know sometimes a lot of agents, every so often you have a divorce case, but how nice is it to have somebody that's a resource that deals with this on a regular basis? He knows how to keep the fights to a minimum. To a minimum. Doesn't always work that way, but anyway, I think it's very rare in this field to have somebody that has that much expertise. So without further ado, Ricky put this class together just for you guys today. Hopefully, also it's interactive. So if you have some questions,
Yeah, so I actually put this class together. I took snippets and pieces out of my 2.0 class. If you guys have ever been in my 2.0 class, it's 2 hours and I literally go over everything when it comes to title, contract, divorce, death, heirship. I mean, I literally cover the whole thing. I wanted to do something different for today, for today's hour class. So I wanted to tackle things that if they come up on your plate, you don't know what to do. That's what I want. That's what I want to do. I want to answer those questions that you're unsure of. So I pulled death, I pulled divorce, I pulled receiverships, and I pulled guardianships. So I'm pretty sure you probably maybe not have guardianship yet, but you will. Eventually you will have a guardianship, and eventually you will have a receivership. Like Libby's saying, I do a lot of divorces, and if you don't know what a receivership is, receivership is the next level of a divorce. When it is really, really bad, a judge gets involved and it becomes a receivership. And I'll cover that. So those are the four main topics: death, divorce, receiverships, guardianships. So I printed out a little, really a top 10, but like top issues that you're going to face when it comes to death, divorce, receiverships, and guardianships. I also threw in a little extra page for notes. There's a lot of information. I'm going to try to just keep it really simple for you guys so you guys can understand it. But please, if you have questions, just let me know. If something doesn't make sense, just please let me know. Okay? So, if you take that out, if you already have it handy, the first thing I'm going to cover is death. So I like to hit you with questions. I like to quiz you. I want to gauge your expertise and see what you would do in different situations. So the first one is you have somebody who has passed away. Let's say the kids have come to you. It's the adult kids. They want to sell the property, and mom and dad have passed away. Okay. What's the first thing that you ask for when it's mom and dad?
If there's a will,
If there's a will, and then what else after that?
probate.
If it's been probated. Okay. And if they say, I have a will, but it hasn't been probated, what do? What's the next step after this?
Who is the administrator?
Say again?
Who is the administrator? Administrator.
Administrator.
Yeah.
The
All right,
administrator.
but if it hasn't been probated,
It hasn't been.
if it's been probated, it hasn't gone to the probate court. So we don't have an administrator, we don't have an executor, nothing's been done on it. Okay? So you can ask them, are you guys gonna probate it? Because if you're gonna probate it, it's gonna take a few months. It's gonna cost a few $1,000s. Okay? So if they have the will, you can say, okay, you guys can probate it. Now, when you have a probated will, we follow the will to a T. Whoever gets the property in the will, that's exactly who's gonna get the property in the will. So there's no ifs, ands, or buts about it. Now, if they say, no, I don't want to probate the will, okay, then we're going to do affidavit of heirship. Okay? There's only two ways to do it when somebody's passed away. You have a probated will, or you have an affidavit of heirship. Okay? The probated will, like I said, it tells you exactly to a T who is going to get the property. The end. The affidavit of heirship is all the heirs to the deceased. And that's when you can have 4 or 5 different sellers. That's when you can have the kids come out of the woodwork, and we've never seen these kids before. And now all of a sudden they're showing face because dad died and they know they got some money coming to them. So you have the probated will, which we listen and follow to a T. And you have the executor, the administrator, everything's been followed nice, clean with the judge and the probate court. Well, we're going to do the affidavit of heirship on. So, like I said, you have a will, but it hasn't been probated, then we're going to do the affidavit of heirship. You have no will. we're going to do affidavit of heirship. So one way or another, probated will, affidavit of heirship. Okay.
Affidavit of heirship is from the probate court as well.
So affidavit of heirship has nothing to do with the probate court. The title company can actually draw it up for you. We can draw it up. We can draw up the affidavit of heirship. We'll draw up the deed. We'll draw up a lot of legal documents for the transaction, and then everything is paid at closing. And another kind of doing the affidavit of heirship is it's very, very cheap compared to a probated will. A probated will, it's thousands of dollars, and it can take months until it's finalized. With an affidavit of heirship, we charge $150. That is it.
That sounds like a no-brainer.
And that's it. But so you have to talk to your client to see which one benefits them. So you can have a will, right? And in the will, it just says so and so is going to get the property, and that's it. And they haven't probated it. So and so is going to get the property, that's it. Now, if you don't do the probated will, and you ask them, okay, if we go the affidavit of heirship route, it's going to be all the heirs. Oh, well, he had 7 kids and 2 kids from a prior. All of those kids from outside marriages now have a cut of the pie. So the benefit is probated will. Pay the extra 1,000, wait a month or so, and that one person is entitled. Or do the affidavit of heirship route, and you're going to have like 8 sellers, and you're going to cut that pie 8 different ways. So you just got to gauge to see what they want to do, talk to them, see how it's going to benefit them if they go to A or they go to B. So you just want to
So
talk to
if there
them.
is no will, it has to be
Needs to be affidavit of heirship.
affidavit of.
Okay. So no will or will has not been probated. We already know it's going to be an affidavit of heirship. Okay. Kind of briefly touched on the next one. It was outside children. So again, probated will, we follow it to a T. That's it. No ifs, ands, or buts. That's what the will says. Affidavit of heirship, it's all outside children. What I mean by that is dad passed away, but he was previously married. And he has 5 kids from a prior relationship, or 4 kids from another marriage, and then he met somebody and then had a good time with them, and then had extra kids. It doesn't matter if they were married, if they were divorced, it doesn't matter. If it's outside kids, they're going to be involved in this transaction. That's outside children. Those are outside heirs. All right. So again, you can open up that can of worms. You can have all these different types of heirs. I call it branches. When you're dealing with heirs, think of the trunk of the person who passed away, and then it's going to branch out to all the heirs. And if that heir is dead, it's going to be their heirs and their heirs until we stop at our probated will, or we just run out of heirs. Okay. So I think the most I've ever done was like 7 sellers. It wasn't anything crazy, and I had all their spouses too. The spouses have to be involved. It's Texas, community property. So we needed them to join in, and of course, most of them didn't live in the property. They were adults, and they had their own homes somewhere else, but they still have to be involved to sign off on homestead affidavits, basically displaying the property. So it doesn't matter who you're dealing with when it comes to probated will or an affidavit of heirship. You're dealing with outside children. We want to know the spouses of everyone that's involved. Any seller, we want to know their spouses. They're married, they're divorced, they haven't lived in the property. So we need, not only am I closing 7 sellers, the heirs, but now I have their spouses in the office, and now they're signing on. When I'm a manager, my previous manager, the most she had, I think, was 50 sellers. And because it was all children, and then those children passed away, so it was their heirs and their heirs and their heirs. Normally, a deed, we charge $150 just for a deed. It's a standard deed. We do it every single transaction. For this deed, the attorney charged $1,500 and wanted the payment up front because it was just pages after pages after pages after pages. And if we give that to the client, they can just take the deed and just not pay us and cancel the transaction. So that's what I talk about outside children. You want to know if there's outside children, if there was prior relationships, prior marriages. I can only ask so much when it comes to personnel questions because I'm not the representative, and for legal reasons, I can't go too in depth, but you can. You're their paid rep. You can ask them what's going on, what happened. Did dad have a relationship, prior marriage, whatever. Because if we leave somebody out, if we leave an heir that's out somewhere, they can come after you, and they'll come after me. And they'll sue everyone. Yes, ma'am.
I'm assuming if these children of heirship are minors, does it get more complicated?
Well, that's the guardianship portion. So it gets too complicated, it's just extra steps. But even underage minors, we can't just get rid of their interest because they're under 18. All right. 3, still on death. I see a lot of previously drawn up affidavit of heirship. So if you're dealing with a client and they say, no, I don't have a probated will, there's no will, or we have a will, we're not going to probate it. But they say, well, mom and dad, we had an affidavit of heirship drawn up for them already. We were going to close at so title company, and we had this attorney, John Doe attorney, draw up an affidavit of heirship. Here you go. And they give it to you. Now, you're not a legal expert. You're going to look at them and go, okay, it says affidavit of heirship. Give that to us immediately. Give that to your title company immediately. Just because they've already gone ahead and drew up an affidavit of heirship doesn't mean it's correct.
Yeah.
There could be information missing. A couple of things that we look for when it comes to an affidavit of heirship, and is very, very important, is to disinterested party. Somebody who is not the one founding them, somebody who doesn't have an interest in the property, somebody who's known the deceased 10 years or more. Like there are specific requirements that these witnesses have to oblige by in order for them to be good legal witnesses. Why? Because an affidavit of heirship is basically saying John Doe passed away and he only had these 2 kids. That's it. We have nothing else to fall back on. So we need 2 witnesses to attest to that. And so these witnesses can have an interest in the property. They can be paid. They can be a realtor getting commission. They have to have known the person for at least 10 years and have no interest in the property whatsoever. Because if it ever does go to court and there ends up being 5 kids instead of 2, well, you got 2 witnesses and they attest to the information that was on the heirship. So if they ever give you the affidavit of heirship because they had it previously drawn up, we were going to go under contract a few years ago, so we hadn't done that time. Here you go. Okay, cool. Thanks. I'm going to give it to my title company and then I'm going to take a look at it. I'll have underwriting take a look at it. I'll have my attorney take a look at it. Okay. So you may see that from time to time it does pop up where they've previously drawn up the affidavit of heirship because they were going to close somewhere else and they want to kind of get their eggs all in a basket, get everything ready to go, and they just did it incorrectly. Then we have to draw up a brand new heirship. So it's time consuming and it's going to cost money. Okay, died recently. So just because we're going to do an affidavit of heirship doesn't mean that everything's kosher and doesn't mean everything's okay. If the guy died a month ago, more than likely our underwriters are going to say no. I already know what underwriter that I will take it to them, but they are going to be very strict on the requirements. So if somebody's passed away a month ago, that doesn't give their creditors enough time to file liens against that person. They still need to get paid. Creditors still need to get paid. Contractors and engineers still need to get paid if they did work on the property. So if somebody's passed away a month ago, 2 months ago, I'd say up to 4 months ago, come to us immediately and let us know because there's going to be extra requirements. The main requirement is we want to make sure that there's no outstanding debts out there that we don't know about. So we'll probably ask for like an inventory list. We want you to fill out an inventory list and say they had all these credit cards, 0 balances. You're gonna have to show us proof. Basically, we want to make sure there's no debt collectors out there waiting because if they closed a month ago and then we close, they're going to come knocking on your door. Okay, we need to give them enough time. So just because they died 4 months ago, that doesn't mean we can't close. We just have extra steps we got to go through. Okay, it's very, very rare to have a transaction where you just can't close. Like Lynn was saying, we shopped around at different underwriters. It's very, very rare that you're just at a dead stop. There's a way to get it closed, but we're going to have extra work to do. Extra homework, extra steps. The seller's going to have to get involved. They're going to have to prove this, this, and this. There's a way to get every deal closed. It just may be a little harder at times. Okay. Any questions on death so far? So I'm going to kind of transition it over to divorce. I will touch on the guardianship. I'm going to talk about minors and heirs. But anything about death, if you have any transactions, you've had issues in the past, I've covered probated wills, I covered affidavit of heirships. And like I said, those are really the only 2 ways that interest can change. It's got to be a will, it's got to be an affidavit of heirship. Okay. Okay. Now I'm going to go over to divorce. And if you guys ever want to sit down and just kind of have ring, you can just reach out to me. You guys have my information. If I'm free and I don't have any closings, you can swing by the office. I'll hold a closing office or closing room for us, and you can just pick my brain or I want more in-depth information about receiverships or divorce. Just reach out to me. Okay, so divorce. A divorce is not final. The seller comes to you and says, "I want to sell my property, but my divorce isn't final." Can they sell their property?
Yeah, they can sell it.
They can sell it?
I mean, they just have to make sure that, they just do the split, whatever they.
You can tell it.
Yeah.
You're not divorced. Your divorce isn't final. So you're not divorced. So you can sell it and you're going to sound like husband and wife, whether you like it or not.
See
They
each
don't.
other.
We're still going to have to interact somehow if your divorce is not final. So yes, you can sell your house. On the deed, it's going to say husband and wife, and I've had people have issues with that. And I'm sorry, your divorce isn't final. So yes, if your divorce is pending, you can close. You have to agree to the proceeds. I need to know if it's going to be like a 50-50 split, a 60-40. There's only so much that a title company can enforce when it comes to a divorce decree. I have my underwriters always remind me, Ricky, you cannot enforce a divorce decree and the terms on the party. You have to follow it when it comes to like the real estate transaction, but on the divorce, it'll say Jane paid Spectrum and the utility bills from these months and the mortgage payment from that, and she's entitled to. You tell me the amount. I don't. Yes, it says it on the divorce that she's entitled to all the back payments that she's made on the. I don't know what the numbers are, and I don't know. Maybe John Doe reimbursed her off the paper. I don't know what happened. So for every single one of my divorces, and the agent that gives me his receiverships, he already knows. I will not look at the dollar amounts in the divorce. I want your parties to agree to what they're going to accept, and they're going to sign it at closing. It's called a proceeds allocation. Basically, it's John and Jane telling me what they're going to get, and they're both going to agree to it. And if they don't agree to it, then we're not going to close. So I don't care what the divorce says. She gets 10,000, he gets 5,000, all this, and they don't agree to it, then we're not going to close. You have to agree to the bottom line at closing. So if the sellers Jane has made extra payments on the mortgage and she's entitled to it, cool. You need to make sure that John Doe is aware that the title is going to show those proceeds just like that. She's going to get extra 10,000 or whatever it may be. They both have to agree to the terms. Now, in a divorce situation, I'm going to require a copy of the divorce. So, and the only reason why I will get a copy of the divorce, now I threw in the title commitment, and I think it's probably the next document underneath it. I'm going to go over the whole entire commitment, and I really just wanted the first page, but it kind of like a little funky just printing out one page of the title commitment. So I want you to be familiar with the title commitment. Now, if a divorce isn't final, and I do the title commitment, which is basically me running title, I run their names, I run the property address. On number 3, that's what I look at. What's on number 3? Owner of record. That is who is entitled. And I'm going to go back to number 3 when I go to receiverships and guardianships. I'm going to constantly be talking about number 3. But number 3 is the last owner of record, last deed that was filed, last probated will or heirship that was filed. Okay. Now you have a situation where it is a divorce. They are going through a divorce. It is pending. So if it's pending, then whose names are going to be on number 3? Owner of record. If the divorce is pending, whose name is going to pop up as the vested owner? It's going to be both. When it's final, then this is going to change. Okay? Because the deed was the last vested document. That was the last public record showing us who's entitled. Okay? So I have Jane Doe. She's coming to you and says how you have the divorce. And it's final. She tells you it's final. Here you go. Here's the divorce. She gives you like page 13 and it says Jane Doe gets the property. Okay. And then I run my title and I say, oh, hey, so and so, here's a title commitment. And number 3 is saying John and Jane Doe, even though the divorce is finalized. Okay. Why is that? The divorce is finalized. Why isn't it showing here?
Records haven't yet been updated.
Very close. So they have not reported that divorce decree. There's no way for me to know. I only pull public records. What is filed with the public records? So if they never filed that divorce decree, and more times than not, they did not file it, because this is what happens when a divorce gets done. You go to the attorney, he finalizes the decree. Here's a certified copy, Don Doe. Here's a certified copy, Jane Doe. Okay, our divorce is done. And that's it. Nothing happens. Take that certified copy, record it with the county records, and now it's just going to show one name.
So now, Ricky, just to to go back real quickly. The divorce decree is not recorded a public record because there might be children involved and stuff, and there might be other things going on. So what it is that an attorney that knows what they're doing will actually get the buyers, I'm sorry, the spouse to the spouse. They might do a general warranty deed, a special warranty deed, so that way society knows that it's been conveyed or whatever. But there many times they just don't record in a public record for that reason. Now, if somebody forgot something, and correct me if I'm wrong, the only way to get that toxic husband off is it's in the divorce decree is to register all 100 pages of the divorce decree.
Absolutely correct. So buyback, like you were saying, it's a great point. In order for them not to report it, give me a deed, or he's going to join in, which is going to be part of the deed. So if you don't want to give me a certified copy, and that's why I don't know if you caught it, where I was like, she only gives you page 13 saying she got the property. She can't record page 13. I need the entire certified copy of the divorce decree, and only a certified copy. When it comes to copies and recording documents with the county records, the courthouse can only accept an original signed document or a certified copy, not just a regular copy. Okay, so either you give me the certified copy and I'll record it, and then it'll update the vest, or John has to do a deed over to you, or he needs to join in on the transaction, and that's happened. They didn't want to give me a certified copy, so he had to join in on the transaction. Sign off on his interest. Okay. So if they give you page 13, it's might to be because they're trying to hide something. Now, of course, I'm not going to say every seller is trying to hide something, but in this business, you can only trust yourself, really. Okay, you got to be very, very, very careful. Seller, they are about to buy online. Okay, they will hold your feet to the fire. So be very careful when they give you page 13. Okay, thank you, give me everything. Because there could be also liens that need to be paid off on the divorce decree. They're called OT liens. OT liens, I'm going to collect on them. An OT lien is saying Jane Doe gets the property, but she needs to give $50,000 to John Doe from the proceeds of the sale. Oh, but that was on page 14. They give me page 13. And that's happened. Okay. You want the full copy, the certified copy. And if they don't want to give it to you, or it's in storage, it's in a box, okay. Are you okay with the title company ordering it for you? It's going to cost a few $100, depending on how many pages. Like you're saying, if it's over 100 pages, the courthouse charges per page. It's going to be a few $100 to get that copy. They can just give it to me themselves. Okay. So when it comes to divorce, just to recap, there's going to be a few ways to change that interest, and you give me a certified copy, and I'm going to report it with the county records, and then and John or Jane Doe is entitled, solely entitled, or I need that deed that they did, special warranty deed, or it's all going to join in. Okay. So you got to get that certified copy.
Excuse me, I'm gonna go. Are they here? Oh.
That's what I was supposed to do.
You're good. Sorry, what you doing?
Yeah.
This is very interesting. Very interesting.
Oh, yeah. I have a lot of white hair and a lot of them on my office. Oh, yeah, and we keep tissue in the closing rooms for the criers. We have criers, and then of course we have people celebrating. And I'm talking divorce situations. Divorces, they're celebrating or they're crying. And the stories that I could tell. Good Lord.
Do you have security and such?
I'm the security. I'm the only guy in that office. I'm the security in the IT and the janitor. Okay. So we're still on divorce. Let's see. That's kind of already touched on this. Divorce 3. Divorce states one party gets a lot more money than the other party. The other party just doesn't agree. We're not going to close. Okay. Like I said earlier, both husband and wife, or wife, husband, whatever it may be, both parties have to agree to the proceeds split. If you're not doing it 50-50 and you're only doing it like a 90-10 split, both parties need to agree. And then just real quick, so we're on divorce and we're on number. So everyone has to agree to the split. If not, we're not going to close. And I've had transactions where this is why I will cover my butt to a T. Not only do I put the split on the closing disclosure and it'll say Jane Doe gets this, John Doe gets this. Not only is it itemized here, but I also do the proceeds allocation form saying Jane Doe gets this, John Doe gets this, and it's signed and it's notarized. Now I have two things to protect me. I do that on every single divorce situation. On one transaction, she came back to me the next day and was like, "No, I need more money. Oh, I was entitled to more." No, you're not, because you agreed to less. So there's no way. And if I didn't have something to protect myself, then I'd have claims and issues. But no, she wanted to come back, even though she signed off on the proceeds form. She wanted more money afterwards, I guess, and let it simmer for a while. How much money less, or how much less money she was getting, and then came to me. Not on my watch, because you signed off on it. Number 4, parties want to keep everything separate from one another. Only so much. I can only keep so much separate from each party. Both are going to sign the closing documents, okay? But I can keep them physically separated.
Yeah.
I can sign him at 9 a.m. and her at 3 p.m. That's not a big deal. At my other office, I don't know if you guys been to our current office, it's main lobby, and you can see all the closing rooms. So I can't really hide one person. But in our other office of 281, we have a hallway of the closing rooms. And if we had a situation, I would keep all divorces their time separately. But sometimes one of them late, one comes early, whatever it may be, and they may bump into each other. I will hold one in the closing room. I will walk one out the exit, and then I'll walk the other one out the front door. Like, you will keep them separate, just because I've done so many divorces, and sometimes they don't play well. So if they want to keep everything separate, cool. I can only do so much though. You're going to see each other's names on the closing documents. I had a situation where it was a divorce, and the wife did not have an agent. The ex-husband had the agent. And the ex-husband was signing with the POA. He was signing as a power of attorney. Okay? He was using somebody to sign for him because he didn't want to be anything. He had nothing to do with the lawyer. At the beginning of the transaction, the agent for him tells me, he's like, "Hey, Rick, I need you to keep all the paperwork separate as well. Like, give them individual signature stuff. If I need her to fill out a seller form, do it, just everything separate." And I said, "Okay, so and so." I can only do that so much on certain paperwork. If the deed, both names are going to be on there. There's going to be things where both names are going to be side by side. The person that he chose to be his POA was his mistress. It was the person he cheated on his wife with. So that's why they wanted the names separate. Okay? And I put out literally like the day before closing. And so I do the proceeds. Everything is split, like I just said. Proceeds, everything's split. Everybody has to agree to all the terms. And then they get the amount that you are agreeing to days before closing or the day before closing, not the day of closing. If you have not given me the proceeds split, we are not going to close, because I'm not going to deal with a Jerry Springer situation. Like, you give me the figures. So he chose his mistress to be his POA. And I kind of felt like, dude, you could have picked anybody else, but you picked that one person. And so the ex-wife had no idea until closing date, when the names are on the deed, and she sees the names side by side. And she looked at it and just tears. I can't believe that SOB picked her to be his POA. It was a bad situation. That's why I say I keep tissue paper in the terms for the brothers. And she cried, and whatever. So we got through that moment, very, very emotional moment. And so she signs off the proceeds form. Let's say example, she's getting 50%, he's getting 50%, no, maybe. She agrees. And so now the POA comes in with the agent. And as soon as we sit down, the agent brings in the mistress. He said, "Rick, hold on a second. Before we start signing, I'm going to make a change." Closing table. Everything smiles. It's like, "Okay, what are you doing?" He goes, Jane Doe thinks, the ex-wife thinks that she's gonna get 50%, but we're actually gonna reduce it. We only told her 50% so she can get to the closing table. She wasn't gonna come to the closing table. So she's not gonna get 50%. We need to reduce it to like 40, 30%. I'm just staring at them and I'm just staring daggers thinking, I know you're not telling me this right now. I said, "Okay, I'll do whatever you want. You can change whatever number you want. I need you to bring her back in and she's gonna sign everything again. She needs to agree to those numbers." Okay. And the mistress and him are talking, and he's like, "Okay, well, just leave it the way it is. Just leave the numbers the way it is." And I'm just thinking, like, how could you? No, I'm not gonna. Once one party has agreed and signed off, nothing will change on the paperwork. And so he accepted it. The mistress accepted it, and they signed off, and then we closed. But it's stuff like that. You gotta really be keep an eye on, be mindful of who they're choosing to sign on their behalf, because you could have a sticky situation like that. And like I said, it all comes down to dollar and cents. They want more money. They don't care about who you are. They want to pocket more money. So be very, very careful. Make sure that you're protected, like I'm protected. I have CD. I have the seller proceeds form. You are going to agree to my terms.
That agent needs to go back to ethics class.
And I was not people that one penny. I mean, how many years? He's been with me since the beginning, 9 years. And he knows his stuff. Wow, for those stretch.
Yeah, and if I'm helping that just real quick because we're talking about ethics, of course. Don't put yourself in a situation where you're choosing, especially when you know the people, when they're getting a divorce, in a compromising position, and because it's not worth it, guys, number one. But the other thing is also is that if they when they purchased the property, the wife might have not been working, so she only signed the deed and the closing disclosure. But let's say they're getting a divorce, the wife who is not on the loan because it's community property must sign your exclusive right to list and your seller's disclosures. They need to be on the note from beginning to end because otherwise they just can't show up to closing and your closing package didn't have their signature everywhere. They must be on everything from beginning to end. Okay.
Yeah. Even though they're like a non-borrowing spouse and they couldn't be on the loan, Texas Community States. So I get a lot of sellers where they think they bought it by themselves because they were a non-borrowing spouse and now they want to sell. Well, sorry, your spouse is going to join you.
Let me ask you, because I have this situation happening right now. And I have so it's a couple, they're married now. When he bought the house, they were dating, they were engaged, not married. But he bought the house on his own without her. But then, moved in, she has put money into it, she has paid for stuff, she has changed flooring, blah 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 blah. But he's telling her, no, you don't own it. And I'm like, no.
So they're married or they're not married?
They are married.
Oh, they are married.
Yeah.
And she lives there?
Yeah.
Primary residence?
Yes.
More than 6 months?
Yeah.
She's going to join it? 6 months or more, I tell everybody that's from my attorney. That's the key time frame. If that person, that spouse, has lived in that primary residence for at least 6 months or more, you're going to join it. I mean, you can even do common law.
Can you say that?
Yes. So you yeah, 6 months or more, you got to join in. I don't know, TikTok.
No, this is actually going to her mom. Her mom and I are like going after things.
Especially if she's putting money into the property.
Yes.
If she's helped with mortgage, if she's paid utility bills, if she's getting
The
mail
down
there.
payment. She helped with the down payment.
Well, if you're dealing with a hostile
Oh,
situation,
yes.
what you need to do is get that marriage certificate filed in public record on the
Oh, and she
on the
just
property.
served him
Okay.
yesterday.
Yes.
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 You.
Okay, so we have divorces, and now we have divorce situations that have gone really bad, and then they turn into receiverships. Okay, so what a receivership in a nutshell is: him and her cannot get along. They cannot talk to each other. They cannot see each other. They are sick of one another. They cannot play well. Okay, the divorce goes to the court. The judge now orders this third party, who has nothing to do with him, as the receiver. So he is going to sign everything for you. So if done properly on a receivership, I think my agent, who all he does is receiverships, he'll give me the property address. And be, hey Rick, I got another one coming up at 23 Street. Go ahead and pre-work the title. So we'll pre-work the title. I'll do the title work, and then owner of record will say his name, the receiver's name. John Doe, receiver for Jane and Jack Doe. It's not actually going to say the actual owners of the property name under owner of record. That's because the order, the receivership order, was filed of record. And now the receiver is technically entitled. And in that situation, the actual owners, Jack and Jane Doe, the actual owners of the house, I can't talk to. They're not on the contract. The contract is going to say my agent's name, receiver for so and so and so. So if they call me up, if the actual homeowners call me up, I'm sorry, talk to the receiver. Or the receiver needs to give me permission to talk to you because I'm not. You are literally not a party of the contract. And I can be in trouble for talking. That's just like anybody off the street calling me up and asking me what's going on with the contract. That has nothing to do with it. Okay? A receivership that's done properly and filed of record will show the receiver's name. So you may not run into that. You can run into that on a buying side. Usually, when an agent is a receiver, they're on the selling side. They're handling the selling situation. So you may be on the buying side where you come across a receivership or a divorce situation where the agent is actually the receiver. That's going to be your seller. That's the person you're talking to. Okay? With a receivership, I need the order. I need the documents from the courthouse granting this guy to sign off as a receiver. So, like I said, you won't really face that unless you personally want to do a receivership. You can have a deal where it is a receivership and you're the agent. That's fine. You have this guy who's your receiver, but you're just handling as an agent the realtor side of it. You can do that. But more times than not, you'll see it on the buying side. Usually the receiver is the agent because they get 4%. They get 4%. My agent, every single one of his receivers, it's 4%, 4%, 4%. And the thing with receiverships is the actual owners hate his guts because they had no say on this guy representing them. It was appointed by a judge. And that judge says, hey, this realtor is going to be a receiver. It's in the order. He's going to get 4%. And basically, it's what he says. So I'm talking to the agent receiver. I'm talking to him like he's the homeowner. He's telling me what's going on. Okay? That's a receivership. When it's just so bad, they cannot get along. Where does the money go? If you have a receiver who's technically entitled, who's technically the owner, and he's signing off on the property, that money doesn't go to the receiver. It's go to the court. Okay. Rare instances, him and her will actually get along and give the receiver their banking information, and it'll say it in the order, splitting 50-50. That's a rare situation. We'll cut a check to them. But more times than not, on a receivership deal, that money goes to the court, the registry court. And it stays there until they can get along, until their attorneys can come to some sort of agreement. Okay. That is basically a receivership. Money doesn't go to the seller, it goes to the court. Are the sellers involved in the transaction? No. Like I said before, not at all. Unless that receiver grants me permission. They will not talk to me and I will not talk to them. And it's kind of a weird situation. They're the owners of the property and they call me asking me what's going on and I can't tell them anything about their house. And it's because it got so bad.
They acted like children.
Yeah, you are not a party of the contract. Your receiver is.
Now, daddy and mommy have the contract.
You sit to the side, let the adults handle it. So that's basically the receivership. Now, guardianships. And once I cover these, I'll come and do a kind of overview of each category, each topic to just make sure everyone feels comfortable on each one. So, guardianships. There are different types of guardianships. We're going to talk about the heir that is 13 years old. If you do with the affidavit of heirship and a minor is an heir, they're still entitled. You're not going to sign unless a guardianship is set up for that minor, which means you go to the court and the judge is going to appoint somebody to be the guardian over the minor. Okay, and now those funds are going to go to the guardianship in benefit of the minor. The minor's involved. Now, the minors, I'm not going to have a 7-year-old walking in, signing in closing documents. It's going to be the adult guardian that was appointed by the court. So it doesn't matter their age, they're going to be part of it. They're going to be part of the interest. Okay. Seller's too young, got it. Seller is not of sound mind. So I have a guardianship because he's too young. I'm going to do a guardianship if you are not of sound mind. Okay, so you have somebody they're trying to sell their parents' house. Their parents have dementia, they have Alzheimer's, they're not of sound mind. You can do a POA. Okay. POAs are invalid for people that are not of sound mind. It's a medical POA. So if they did not get everything taken care of before mom and dad's mental decline, you cannot just all of a sudden do a POA and sign on behalf of it. Because if you've ever done a POA before, if you ever went to closing and it was a POA, I personally will call up the person, they're called the principal, that's not here, and I want to hear their voice, and I'm going to ask them random questions, and I want to make sure they're of sound mind and they know what's going on. If they're not, if I feel uncomfortable, we're not closing. Okay? And I've had that happen. They don't know what's going on. They don't know the property address. They don't know anything about the transaction. We're not going to close. So you cannot do a POA all of a sudden at that time. You maybe could do a medical POA, but you'd have to talk to their direct physician. And I would need to see a physician letter and the POA. But in that situation where it's like too late and you didn't get anything set up, you're going to have to do a guardianship. And so we have a guardianship for people that are too young, and we have a guardianship that are people that are not of sound mind. Okay? You can have somebody who's elderly. They are of sound mind, but they physically can't sign. You don't really have to do a guardianship for that. You can still do a POA because I'm going to ask them. And I've had people actually come to the closing. The POA, the principal, because they were elderly and they will have in a wheelchair and they're perfectly fine. Mentally, they're of sound mind. They just physically can't sign. And we'll do a POA right there and then. And I call what's ratifying the POA. That's when I call them up. In this case, I'm literally just teaching them. Is the POA still good? It's still active? Yeah, everything. Perfect. So in that situation, you wouldn't do a guardianship. You do it like a POA if they are of sound mind. Seller is in a nursing home, have dementia, have oral Alzheimer's. Okay. It's still kind of touching on that same situation. You can't do the POA. Now, in that case, I have seen where they're already in a nursing home or a living facility, a medical POA has been set up because they already knew what was coming. So if they ever give you a medical POA for somebody with dementia or Alzheimer's or somebody who's not of sound mind, I need the doctor letter, the physician letter. So I need the medical POA. I need the physician letter too.
And the power of attorney gets done before the decline, or even if the decline has already happened, does the doctor?
Before. But it has to be
It
before.
has to be before,
If it's already after, then
and then it's
we're
gonna
too
be the
late.
guardianship.
We'll have to do a guardianship.
Okay.
Yeah. So if you give me a POA, now you can actually do this. You can give me a POA that's not a medical POA, but it was set up, it was signed by the principal when they were of sound mind. It was signed 5 years ago. They had the mental decline in the last year, but it was signed 5 years ago. I will talk with your doctor. The doctor will confirm with me, yes, John Doe 5 years ago was of sound mind. His mental decline happened in the past year. Okay, we're good.
Okay.
Because the POA was active
Was done.
at that time,
Okay.
and I had the doctor sign off on it. So, yeah, you can have a POA that was done years before when they were. You cannot sign a POA when they are not.
When they're not sent.
Right,
So
too late.
it's not even like if the doctor said, yeah, you should be taking care of that.
No, it's
That's
already too
gonna
late.
have to go into guardianship.
Okay. Court intervention. So basically, the guardianship. I kind of already touched base on that. The guardianship the court has to intervene when it comes to that. When it has to do with a young minor, when it has to do with somebody who's not of sound mind and you can't do the POA, we have to do the guardianship. The guardianship is not an overnight fiction. You can't get that overnight. Remember, think about that. When you ask questions, when you're talking to your seller, when you're talking about death, when you're talking about divorce, you need to ask all these questions up front because when you do your contract, you need to get all the timelines ready to go. Usually when I have a guardianship deal, it'll sit on my desk. The last one sat on my desk for about, good Lord, 6 months. And it was an heir situation. And it really was just a court stuff. It was a guardianship. It was an heir. So it waited, it went for so long that the sellers came to me and said, we're just going to wait until they're 18. I said, okay, that's fine. So I think that one we actually waited, I mean, until like 7, 8 months later. Then they turned 18 and then we signed and everybody was happy. So, okay, so just a quick overview. When it comes to death, I need a probated will or I need an affidavit of heirship. So there's only one or two ways that interest is going to change hands. Interest can only change hands basically a handful of times. A deed, a divorce, a probated will, an heirship. That's it. So yeah, one of two ways. And if not all the parties are on board, if not all the heirs are accounted for, we are not going to close. Okay, I had one seller call me up, a little lady, her husband passed away. She had adult children, and they were all willing to sign up on the paperwork. But her husband was previously married, and his son was a homeless person out in Cleveland. And she wanted to know what could we do. There's nothing we can do. You can hire a PI and you can go and look for him, but you cannot just sell dad's interest because he's a homeless person and you can't find him. His interest needs to be accounted for. He can sue you and he can sue me. So probated will, affidavit of heirship. You have a will and you don't want to get it probated, affidavit of heirship. There's only one of two ways. You can give me, so if you know you're working a deal, and you know somebody has passed away, you can actually give me the address and we can start the title work ahead of time without a contract. So we can start the affidavit of heirship process. I do have a lot of agents, they reach out to me and say, hey, Rick, give me the questionnaire. Every affidavit of heirship starts with a questionnaire. I give it to you, you give it to your seller, or the next of kin, whoever is going to be the actual heir. Literally is just a questionnaire. Mom died this date, she has these kids, they're alive, or they passed away. It literally is just a questionnaire. It's an overview of the person who passed away. Then you give it back to me. I review it. My underwriter reviews it. They approve it. I give it to my attorney. They draw up the heirship. Now I have the actual legal affidavit of heirship that's going to change interest. Then I give it back to you, and now the two witnesses are going to sign, and that one next of kin is going to sign. So you can start that. You can give it to me now. You know you're going to be dealing with that situation. Hey Rick, give me the questionnaire. Okay, here we go. Here's the questionnaire. And I actually give you like a how-to step 2. Here you go. Fill it out. Give it to me before I even have the contract. Because trying to get two witnesses that have known for 10 years or more, they're not family. They're either friends or coworkers or neighbors. Kind of hard sometimes, and that can be very, very time consuming. You do need to get their signatures notarized, so they need to be somewhere local, or I got to set up a note. You just want to make sure you start taking care of all that stuff before the contract hits my desk, because we're probably going to have a delay in closing if we have to go through all that. Okay, so that's death. Divorce, it's not final. I don't care, you can still sell. Okay. If that divorce becomes final the day of closing and nobody gets signed off, we're signing at 10, and it became final at 9, we are not going to close. I need to see that divorce decree. Okay. Sometimes, and they've done it on purpose too, the sellers will purposely just wait on finalizing it. They just want to sign and get everything taken. Okay, that's fine. Because if it's not finalized, I'm not going to look at it. That means nothing to me. You're going to sign as husband and wife, and you're going to get right to the proceeds. But if it's finalized, simply before closing, we are not going to sell. I gotta see. Okay. It's not final. Of course, they can sign. They're going to sign as husband and wife. I can keep everybody separate. If it gets really, really, really bad, it goes into receivership. That's when somebody has to step in because they can't play well. So receivership handles all of their affairs, and they have no say in the transaction whatsoever. And that money is probably not even going to go to them. It's going to go to a court. And it's going to sit there until they can play well, until their attorneys can agree on something. And then you have the guardianship. That's when somebody is a minor. The court has to intervene. That is when somebody is not of sound mind and you cannot use a POA. You have to do the guardianship. Any questions on any of those topics? You guys are good? Everything's good? No confusion? I know I probably bored some of y'all. I'm sorry about that. But that's it. All right. You guys are all set?
It was good.
Thank
Okay.
you.
Pleasure.
Thank you.